Good morning, my Political Science 200 students. Today we are continuing with equal rights, discrimination claims, how the court has looked at different discrimination claims, and we're going to continue with that discussion. Okay, so we ended... Well, let's just revisit what we've gone over so far, right? If you file a lawsuit and say, I'm being discriminated against, what's the first question the court will ask?
Classification.
Classification, that's right. On what basis are you being discriminated against, right? And depending upon the nature of the classification, the nature of the discrimination, they will apply different tests, right? So, some classifications are considered non-suspect by the court. They include age and income. And so if you have any law, program, policy, regulation, and any government action that discriminates on the basis of age, what test will the court apply?
Non-suspect.
Right. Well, it's a non-suspect classification, exactly. So they will apply the
rational
rational basis test. Very good. And in order for the policy, program, regulation, practice, whatever the government activity is, as long as it is rationally related to a legitimate government objective, what will the court do? Strike down the policy or uphold it? Uphold it, exactly. And so is that a very easy constitutional hurdle to get over?
No. Well, yes.
Yes.
You need to move your hands.
Well, I know, but we're just going over this one side first, right? And so the burden is on the individual in that situation to show that the policy is not even a rationally related means of accomplishing a legitimate government objective. Otherwise, the policy will be upheld. Now, something that's going on with all this that I should point out is the court also looks at whether the right is a fundamental right or non-fundamental. Right? That's just something to consider in all of this. So is the right to vote fundamental?
Yes.
Yes. Is the right to own property fundamental?
Yes.
Yes. Is the right to buy beer fundamental?
No.
No. Right? So, are there age restrictions on your ability to buy beer?
Yes.
Yeah, they are, because it's considered a non-fundamental right. Right? Make sense?
Yep.
So if the right in question is fundamental, then the court is going to up its level of scrutiny. Not to complicate things too much, right? Okay, then we went over some other classifications. What is the classic example of an inherently suspect classification?
Race.
Race, right? So if you have any policy that distinguishes on the basis of race, the court will apply strict scrutiny, and the burden is on the government to show that the policy is the least restrictive means or a narrowly tailored means of accomplishing a compelling government objective. Make sense?
Yes.
Okay, so that leaves us with the middle classification. What classification do you think is going to be right in the middle here?
I do not know.
Oh, come on. Think.
Gender.
Gender. There you go. And again, we're going to use the term gender because the court does. So, if you're on the cutting edge of the sexual orientation, sexual identity, literature or debate. Don't take me to task for this. I'm using terms the court uses. So don't take me to task. Okay, so let's ask some of the same questions about gender that we did about age. Are there important biological differences between men and women?
Yes.
Yes. Have they taught these to you in the public schools, Natalie, or has your mom had this conversation with you? Or?
Yes, they taught it to me in public school.
Okay, good. Good, now I'm getting my money's worth. Anyway, yeah, there are clearly differences, important biological differences between men and women, mostly dealing with reproductive issues. Correct?
Correct.
Correct. Right? So, is gender more like age or like race?
Race. What?
Are there important biological differences between racial groups?
No.
Are there important biological differences between 2-year-olds and 16-year-olds and 65-year-olds?
Yes, but what I'm saying is, with the race issue, you're never gonna be.
We're not on to that one yet. We're on the
Well,
important
that's how I put it.
We're on the important biological differences.
Well, then don't give me the look like I'm an idiot
It
when I
was-
say that.
Okay, fine. But all right,
I can say things
let's
they
stick
can't.
with one thing at a time. I'm building an argument here. Are there important biological differences between men and women?
Yes.
Yes. Okay, there you go. So, gender is more like age in that regard, right? Next, are women a discrete and insular minority? Are they less than 50% of the population?
No.
No. They're actually more than 50% of the population. So, if every woman voted for other women for elected office, would women hold pretty much every elected office in this country?
Yes.
Yes. I mean, that's just a reality. So the court has said it's our responsibility to protect discrete and insular minorities, and it's just a fact that women are more than 50% of the population. And so the democratic processes are available to them to get what they want. Now, with that said, have women faced a history of discrimination?
Yes.
Were they denied the vote?
Yes.
Yes. So, it takes a while to overcome those disadvantages, right?
Yes.
Also, when you first look at someone, you can usually tell what sex they are.
Most of the time.
Most of the time. Unfortunately, does that make it very easy to discriminate on the basis of sex, say when someone's given a job interview?
Yes.
Yeah. There it is, right? So, when it comes to history of discrimination, been denied certain rights, the sex trait is immediately visible, it's more like race, right? Also, yeah, we were getting there. Anyway, also, when it comes to gender or sex, again, is it a trait which is present at birth and usually persists throughout your life?
Yes.
Yes. And again, I'm not going to get into all the debates over that. I'm going with what the Supreme Court has said on this. And they view gender as a trait which is present at birth, persists throughout your life. Consequently, you're deserving of a higher level of protection, right?
Yeah.
Because am I going to wake up tomorrow and find myself a woman?
No.
No. So is it human nature to sometimes persecute or disadvantage certain groups that you know you will never become a part of?
Yes.
Yes, unfortunately, humans do it a lot of the time, right? So there's some things that make the sex classification similar to age, some things that make it similar to race. So guess where the court is going to put it?
In the middle.
Right in the middle. Gender. Right? And it is going to say that it is a quasi-suspect classification. Quasi-suspect. Exactly. What is meant by quasi?
I don't know. It's something in the middle, though.
It means somewhat.
Okay, yeah.
Yeah, so it's going to mean it's somewhat suspect, right? So the court is going to apply what it calls intermediate or heightened scrutiny. So, intermediate or heightened scrutiny. So, they're not going to look at it as severely as they do when they apply strict scrutiny, right? But they're going to look at the policy a lot more closely than they do when they're applying the rational basis test, right? Okay, so now let's discuss some cases to actually see. Well, no, let's finish it out. The court eventually is going to reach the point where they're going to say, in order for a policy that discriminates on the basis of sex to be constitutional, it must be a substantially related means of accomplishing an important government objective. Substantially related means of accomplishing an important government objective. Okay, so let's actually look at the gender discrimination cases as an example of how the court's reasoning has evolved in this area, right? Okay, so there was an early case called Bradwell versus Illinois, where a woman, Myra Bradwell, wanted a license to practice law in the state of Illinois. And she was told, no, you can't practice law.
Why?
Because Illinois had a law that prevented women from practicing law.
Sexist.
It was sexist. It was in the 1800s, late 1800s, clearly disadvantaged women. But the court upheld the state law. They saw it as a legitimate exercise of the state's police powers. Are state's police powers very broad?
Yes.
Yes. Are they allowed to pass laws that will protect the health, safety, and welfare of their citizens?
They are.
In general, yes, they are. And so at the time, late 1800s, the court saw this as a legitimate exercise of the state's police powers. The state was trying to protect women. They said their natural timidity does not make them fit to practice the law. That's just what they're saying. Right?
I'll fight you and show you timid.
Yeah, exactly. There were a lot of times laws were passed on the assumption that women were fragile, unfit to practice certain types of occupations like the law, and they were upheld under a state's police powers, right? Does that seem fair or unfair to you?
Unfair.
Unfair.
Pretty unfair.
Yeah.
Pretty unfair.
Okay, pretty unfair, exactly. So, decades passed, and then Ruth Bader Ginsburg, actually, before she became a member of the U.S. Supreme Court, started orchestrating challenges to a lot of these types of state laws that disadvantaged women or distinguished between men and women. Right? Okay, and so one of those cases was Reed versus Reed. And this was a landmark ruling. Because up until this ruling, the court had basically been deferring to the states. And so if states had passed laws that treated men and women differently, they just assumed it was constitutional and a legitimate exercise of the state's police powers. Okay? But then Reed versus Reed came along. And what happened was, well, let me ask you. First off, Reed versus Reed. What are we probably dealing with here?
A husband and a wife.
That's right. Husband and wife got divorced. They had an adopted son who passed away before he turned 18. I think he was 16 when he passed away. It is sad. And so his estate was worth less than $1,000, right?
Are they going to fight over it?
They are. Ugh. And so he died without a will. That means he died intestate. That's the term for when you die without a will. Now, Idaho, like a lot of states, had laws, had policies that stipulated what happens when someone dies without a will, right? And so under Idaho law, if someone dies without a will, the estate is handled according to a number of priority relationships. The first is spouse, right? So did he have a spouse?
I imagine not. He was 16.
That's right. So the next was children. Did he have any children?
I don't think so.
No, none that we know. Number 3, is parents. Right? Did he have parents?
He must have.
He did. And they were divorced, and they were fighting over who should handle the estate. And under Idaho law, once you make it to one of these priority relationships, within that priority relationship, any males are preferred to females.
Boo.
Yeah. So once you made it down to that priority relationship, yes, he has parents. He has 2 parents. Under Idaho law, the man is automatically put in charge of handling the estate, right? And just so you know, on a personal note or whatever it is, he did not seem very fit to handle the estate. The woman looked like she was much better able to handle the estate than the man. I think that was one of the things that got her so frustrated by this whole thing, right? Was just like, the law automatically puts him in charge. Any buffoon can see I'm better able to handle money than he can. But anyway, the law automatically put him in charge. She challenged law. The case went to the Supreme Court. And the Supreme Court asked the state of Idaho, why do you have this law that treats men and women differently? Right?
Yep.
And if you are an attorney for the state of Idaho, first off, you're caught off guard because these laws have been on the books for years and the Supreme Court's just been turning a blind eye to them, right? So you're kind of caught off guard. But if you are an attorney for the state of Idaho, what would you argue? Why do you have this state law that automatically puts men in charge of the estate over women?
Well, first of all, I wouldn't be because I'm a girl.
You're right.
Second of all.
But say it's your job.
All right. I would say that men traditionally have more experience handling the estate than women. It's not their area of expertise. It takes a lot of work, and they are not up to the challenge.
That is exactly what the state of Idaho argued. And the court said that is an offensive, sex-based stereotype. Yes, men are employed more than women. The statistics bear that out, right? The employment rate among men is higher than women, especially in the early 70s. But that does not mean that men are automatically better able to handle the estate in every situation, right? And that's what the law assumes. So that's a good argument. Meaning that's the best kind of you can do.
Well, yeah.
Yeah.
No good reason.
Yeah, but the court said no. It's an offense. It's offensive. It's based on sex-based stereotypes, and there are plenty of women who are better able to handle an estate than men. So that argument doesn't cut it. Give me another one.
I have none.
Okay, the other main argument was administrative ease, right? If somebody dies intestate without a will, how much is their estate usually worth?
Not a lot.
Not a lot, right? Usually when your estate starts to become more substantial, then you get around to getting a will, right? And so Idaho said, look, when people die intestate, it's usually because there's not a lot at stake here. And we just want to process these cases. We can't hold an administrative hearing every time somebody dies intestate to determine who's better able to handle the estate. They made that argument to the Supreme Court, and the Supreme Court said, that's exactly what you're going to have to do, right? You can't automatically assume one sex is better able to handle the estate than another. So you're going to have to hold an administrative hearing and decide who's best able to handle the estate. Will that cost the state of Idaho some money?
Yes, it will.
Yes, it will. But the court said, too bad, right? It's going to cost you some money, but you're not allowed to write these types of offensive sex-based laws into law. Just save yourself some money. What do you think of that argument by the court?
By the court, makes sense.
Makes sense. Yeah. It's sometimes, in order to have equality, you may have to sacrifice a little efficiency. Right?
Yeah.
Again, we've discussed different definition of politics. Some people say politics is about who gets what, when, and how. Other people say politics is the authoritative allocation of values. So if you look at Reed versus Reed, what trumped equality or efficiency?
Equality.
Equality, right? And those are competing values a lot of the time in our society. Efficiency versus equality. And sometimes you guys can't have them both. So there it is. Good ruling, bad ruling.
Good ruling.
Good ruling.
Way to go.
Way to go, Ruth
Let's
Bader
get rid
Ginsburg.
of all these laws.
Yeah, well,
Chop, chop.
there you go. Is this ruling was huge because again, it's a shot across the bow of the states, and it's letting you know from here on out we're not turning a blind eye.
Yeah, this was in the 70s.
Early 70s, 71.
1971.
Yes,
1971.
1971.
And we still had that.
Absolutely.
Ridiculous.
Yeah, the women's rights movement didn't really get going until the early 70s. In terms of these legal challenges, you know. So, any questions on that case?
No.
Okay, now this takes us to Frontiero versus Richardson. All right, and this case was decided in 1973. Again, this was an orchestrated litigation strategy, right? Just like with the cases dealing with racial equality, right? This is an orchestrated strategy. So, in Frontiero versus Richardson, Frontiero was a lieutenant in the Air Force. She was an officer in the Air Force, right?
Go Frontiero.
Right, exactly. So, in 1973, how many female officers do you think there were in the Air Force?
Not many. I'm going to say 5.
Right, exactly. I don't have an exact number. In this situation, all you have to do is ask the question, right? And not many.
Yeah.
Right? We don't need a specific number. We just know it's going to be not many. Right? And so the military had a policy. If you were a male officer, then it was automatically assumed that your wife was dependent upon you, financially and otherwise. And consequently, if you were a male officer, your spouse was automatically eligible for every military benefit under the sun.
Yeah.
Type of a thing. Housing and medical, whatever.
Yeah.
Right? Full benefits. Now, if you were a female officer, like Frontiero was, then you had to prove that your husband was financially dependent upon you.
I don't like that.
Yeah, exactly.
If my husband was like a military person, I'd just go out there and get my own job and get this double.
Well, exactly. Right. So, if your husband, Natalie, were a male officer, he'd be getting all his benefits, right? And you'd be getting all the benefits too. And so consequently, you could do consulting work or something else where you didn't need benefits necessarily. You get just paid like money. Exactly.
It's money.
Yeah. So I mean,
like the job I have now.
Well, yeah, exactly. You could be making a lot of money. So anyway, you get the point, right? Female officers, they had to prove that their husband was financially dependent upon them, that their husband received more than whatever it was, 50% of his support from you, whatever it was. And so Frontiero's husband had an outside job. It did bring in some money. They went over the threshold. He received more money. He was not necessarily dependent upon her financially.
But healthcare would be nice.
Yeah, but healthcare would be nice. But consequently, because his own employment and benefits put him over that threshold, he didn't receive the benefits, right?
Uh-oh.
So, case went to the Supreme Court. Now, first off, how is this different from Reed versus Reed? That was an Idaho law, right?
Yes.
Who are we dealing with here?
The very government who's going to be hearing your case.
Well, exactly, right? You're dealing with the federal government, right? Does the court have a history of deferring to the military?
Yes.
Very much so, right? Very much so. And so, equal rights advocates had their work cut out for them this time, because you're going up against the feds and you're going up against the military and military policy, and the court has a history of just deferring to the military, hands off. Does Congress have power to raise armies and navies?
Yes.
Yes. Is that listed in the Constitution?
Yes, it is.
Yes. And so the court doesn't want to start stepping on toes, right? Congress has power to raise armies and navies. Congress has the power to determine these types of things. But in this situation, the Supreme Court took the case and, basically asked the federal government, asked the military, why do you have this policy? And so this is a huge step, them just taking the case, right?
Yeah.
And now they ask the military, why do you have this policy?
Do I have to be the military?
Yeah, so if you're an attorney for the military, what do you argue?
If I'm an attorney for the military, I would say that many men do not provide financially on their wives, and if they do, then we made exceptions for that. However, there are positions
Wait,
available.
what? Many men do not provide financially for their wives?
No, are not dependent.
Okay, that's not what you said.
Okay, well, that's what I meant to say.
Okay.
And now, there are plenty of positions available for men where they can get their own benefits. More than women. Fine, just go.
Okay, I'm not sure I'm following your arguments.
I don't think you are either.
Oh, yeah, I'm sure. Okay, anyway.
They were very good in my mind.
Okay, in your mind, they were great. Okay, so the court asked the federal government, why do you have this policy? And, first off, they say, well, honestly, there aren't many female officers. And you're like, that doesn't matter. And then they said, well, honestly, we're doing it out of administrative ease. We don't have that many female officers, and so it just doesn't come up that much. And we assume that when we did have female officers, their husbands had their own jobs, and were not financially dependent upon them. We assumed when we had female officers that the husband wasn't staying at home taking care of the children. Well, is that an offensive sex-based stereotype?
Yes.
Yes. So the court said, that's not going to cut it. Didn't cut it in Reed versus Reed either. Administrative ease doesn't cut it. So, got to change the policy. Got to make it equal. Good ruling, bad ruling? Good ruling. Okay, so, like I say, this is a carefully orchestrated litigation strategy. You start by striking down state laws that treat men and women differently. Then, the military striking down a policy, that's a huge victory. That takes us to Craig versus Boren. This was a case that was heard in 1976. And what happened was Oklahoma had a law that allowed women to purchase low alcohol beer, 3.2% beer, at 18, but guys had to wait until they were 21. Okay, so who is disadvantaged under this policy? Men, right? So if I'm a gender rights advocate, why would I go after this policy if it's men who are disadvantaged, not women?
Because it doesn't matter. It's so unfair. Yeah,
they're going after the idea that any policies that treat men and women differently without pretty important reasons why are unconstitutional, right? So this guy wanted to buy beer. A woman who ran a convenience store type thing.
Quickie Mart?
Yeah, Quickie Mart. Wanted to sell it to him. So they file a lawsuit together. Case goes to Supreme Court. And let me backtrack now for just a second. So, since I've given you the background of this case. You know Reed versus Reed and Frontiero versus Richardson?
Yes.
Yeah. The court was striking them down using the rational basis test.
Ah.
Yeah. So in Reed versus Reed and Frontiero versus Richardson, the court was striking those policies down using their lowest level of scrutiny. Right?
Yes.
The women were so clearly disadvantaged, the policies were so clearly unconstitutional, right?
Yeah.
That they could be struck down using this lowest level of scrutiny, right?
Yes.
The rational basis test. Okay, well, things got a little more interesting in Craig versus Boren. Who do you think gets in more drunk driving accidents? Men or women? Men. Who do you think gets arrested more for DUIs? Men or women? There you go. So, as you're looking at this, case goes Supreme Court. The Supreme Court asks the state of Oklahoma, why do you have this law that treats men and women differently? And if you're an attorney for the state of Oklahoma, what do you answer?
I would give them the facts.
The facts, exactly, right? And so let's write down the facts. Well, I'll just give them to you since we don't have a chalkboard here, and I'll just give them to you. 0.18% of women had been arrested for a DUI or DWI, whichever one it is in Oklahoma. 0.18%, right?
Yeah.
And for guys, it was 2%.
Ooh, that's a lot more.
2% of guys.
Well, more than 0.18.
See, this is where things get tricky, right? Is there a statistical difference between 0.18 and 2%?
Yes.
Yes.
Just like the difference between the corona and the flu.
Okay, sure. Exactly, right? But case went to the Supreme Court, and the Supreme Court said, you know what? We're going to bump up our level of scrutiny a little bit here, right?
Whoa.
Yep. And the policy is going to have to be a substantially related means of accomplishing an important government objective. So, what is the government objective here?
There isn't one.
No, there definitely is one. What? Why?
Less drunk driving.
Yeah, okay, very good. So what's the government objective framed more broadly?
Drunk driving.
Even more broadly.
Drunk.
Safety!
Oh.
Remember, the state's police powers are very broad. Health, safety, and welfare of its citizens. So, is that an important government objective?
Yes.
Yes, it's even compelling, right? Safety is a compelling government objective. It's an important government objective. It's a legitimate government objective to go through our spectrum back and forth, right?
It is good.
So, safety, protecting people's safety, is one of the fundamental reasons why we establish government. Okay, now, let's return to this. You can't just say safety and you're done with it. The court said in this case, the government objective, if it discriminates on the basis of gender, must at least be important. So, is safety an important government objective?
Yes.
Yes. All right? Now, saying guys can't purchase beer until they're 21, but women can purchase it when they're 18. Only 2% of guys get in car accidents. Is this law a substantially related means of accomplishing the government objective of safety?
No.
No. No. If safety is your objective, what's a gender-neutral way of keeping people safe?
Make them both 21.
Make them both wait till 21. Exactly. Right? Or, have programs in schools that provide better instruction on the dangers of drunk driving. I don't know. I'm not Oklahoma. But the court said, only 2% of guys get DUIs or DWIs, get arrested for it. And this is a very tenuous fit between the policy and what you're trying to accomplish. A very loose fit. It's not substantially related enough, right? They said gender here is a very poor proxy for predicting who's going to drive drunk.
A poor Poor proxy for predicting?
Yep.
Whoa.
That's right. That's alliteration for you, right? So poor proxy for predicting who is going to drive drunk, right? So, make sense?
Makes sense.
Very good. Very good. Okay, so those are 3 of the biggest Supreme Court cases ever. Yeah, I know. There was, well, we need to make sure we get through some other cases so we have time. Now, if we acknowledge that there are important biological differences between men and women?
Yes.
Yes. Okay, so, when those biological differences are relevant, when men and women are not similarly situated, the court goes back to the rational basis test, right? But when men and women are similarly situated, they still apply heightened scrutiny or intermediate scrutiny. Okay? So let me give you an example of when men and women are not similarly situated and the court applies the lower level of scrutiny, the rational basis test still. When it comes to getting pregnant, which gender is at risk for getting pregnant?
Females.
Females, exactly. It's just biological fact, right? Okay, so, case that reached the Supreme Court dealt with basically statutory rape laws in the state of California. And it was called Michael M. versus Superior Court of Sonoma County, right? And so California made it a crime for boys under a certain age to have sex with a girl. But it was not a crime for a girl of the same age to have sex with the guy. Yeah, right? So, in other words, under this law, 2 16-year-olds have sex, cops catch them, the guy's going to jail, the girl faces no penalty at all.
That's unfair, Ken.
Why do you think that's unfair?
Well, because they're the same age. Both stupid, but
Yeah.
the same.
Yeah. So anyway, that's what Michael M. thought. This is stupid. So, case went to the Supreme Court, and the Supreme Court upheld the state law. And they said when men and women are similarly situated, the law does not require them to treat them the same. So when it comes to the likelihood of getting pregnant, only women can get pregnant. So if you were a guy and you knew you could go to jail for getting a girl pregnant, would that deter you from having sex?
Yes.
Well, according to the court, yeah, I'm not I'm not sure that goes through the mind of too many 16-year-olds when they're making this. Whoa. You know, in our state, there's laws that. But anyway, the court apparently felt that that was a rational law trying to accomplish a legitimate government objective. And so they upheld it. I think it's a really bad ruling.
Yeah.
Yeah, number one, I just think it's unfair. I'm like, well, if you have a law that makes it a crime, then, and you want to reduce teenage pregnancy, that was one of the state interests, they said. We're trying to reduce teenage pregnancy. Pregnancy out of wedlock, that type of thing. I'm like, well, if that's what you're trying to reduce, then you can accomplish that by making it a crime for girls to have sex under a certain age, too. So I don't really like that case, honestly. The next problem I have with it is the state honestly going to enforce it?
No.
Yeah. I mean, it's just like it's applied in a wanton and freakish manner akin to being struck by lightning, right?
Wow, that was another case.
That's right. That was in the death penalty cases, but I don't know. I think you'd wind up locking up a large percentage of the teenagers in California if you really planned on enforcing that law. And yeah, great law. Anyway, okay, but you get the point, right? The constitutional principle that is established, which is if men and women are not similarly situated, and they definitely are not similarly situated when it comes to the likelihood of getting pregnant, the court has said that the law does not require men and women to be treated the same. Yeah, exactly. So that's why, again, state laws, state policies that treat men and women differently when it comes to maternity leave, how long you can take off after you have a child, that type of thing. They're allowed to be different between men and women.
Well, yeah.
Yeah. So that takes us to our next case. This one's kind of confrontational. Do women have to register for the draft?
I think we do now, don't we?
We'll get to this in a second.
Yeah.
Right now, I don't think you do.
Woohoo!
Yeah, exactly. I mean, this may have changed. I mean, the next 5 minutes may be wrong. Check it out. But last I heard, women do not have to register for the draft. Do men have to register for the draft?
Indeed, they do.
Yes, they do. Okay, so does this policy treat men and women differently?
Yes.
Yes, right? Okay, so, again, a couple decades ago, a few decades ago, a case went to the Supreme Court dealing with this. The fact that men have to register for the draft when they reach a certain age. Women do not. Okay, so case went to the Supreme Court, and the Supreme Court asked Congress, asked the military, why do we have this policy? And at the time, women were not eligible for most combat roles. Exactly. So at the time, women were not eligible for most combat roles. So here's the reasoning the court used. They said, Congress, the military, they've determined that women are not eligible for most combat roles. Therefore, when it comes to the likelihood of having to serve in a combat role, men and women are not similarly situated. Congress has power to raise armies and navies. And consequently, since men and women are not similarly situated when it comes to having to serve in combat roles, women don't have to register for the draft. So that was the ruling in Rosker versus Goldberg, and that was the reasoning, right?
Yep.
Okay, now have policies changed?
They have.
They have. Now are women largely eligible for combat roles?
Yes.
Yes, they are. Consequently, if you look at the court's reasoning, should women have to register for the draft now?
Yes.
Yes, absolutely. But here's the thing. Who decides which cases the Supreme Court takes?
Congress? The Supreme Court?
right now in the Supreme Court. Yeah, exactly. So basically, you're right. Congress could pass laws saying the court has to take these types of cases. But basically, where we are right now is the Supreme Court basically has almost 100% control over which cases it takes and which cases it doesn't. There are just a handful of cases that they have to take. Otherwise, they have pretty much total discretion over their docket. So, here's my question for you, Natalie.
Okay, Carl.
Are they going to take a case dealing with this anytime soon?
They're going to have to at some point, whenever we have our next war.
Well, yeah, exactly, right?
So it's only a matter of time.
Yep. If the court doesn't want to deal with an issue, guess what it can always do?
Say no.
Just not take the case. Exactly. Again, they have a history of deferring to the military, and they'll probably just leave this one for later. But who knows? We'll see. Maybe they'll take it. Well, class, as always, it's been a pleasure. Hopefully, this all makes sense, and we've gone over particularly the gender discrimination cases to see how the court's Equal Protection Clause jurisprudence has evolved, specifically how it evolved in the area of gender discrimination, but it evolved similarly, in different ways, but it evolved in the racial discrimination cases as well, and it evolved in areas dealing with non-suspect classifications as well. Make sense?
Makes sense.
Any questions?
No.
All right. Well, take care. Bye, class.